Thank you for being here with us today. This session that we have is Finality of Arbitral Awards, Principles, Practice, and Pitfalls. I'll first introduce my co panelists here. We have Akshay Sharma. Akshay is a partner in the arbitration and dispute resolution practice at Shardul, Amarchand, Mangaldas and Co. in Delhi office. He regularly practices and advises clients in both international and domestic arbitrations as well as in commercial litigation before Supreme Court, High Courts, District Courts, and specialized tribunals. Then we have Raunaq. Raunaq is a partner with Saraf and Partners. She's also an arbitration and commercial disputes practitioner with over 16 years of experience. She also handles investment treaty disputes, commercial litigation, and her expertise is in complex matters involving foreign investment structures, joint ventures, cross border enforcement, and multi jurisdictional conflicts. Next, we have Hina. Hina is an advocate practicing for more than 10 years in arbitration and commercial matters. She set up her independent practice in 2023 under the name of HNS Chambers. She's represented non banking financial institutions, construction firms, solar companies, PSUs, and other commercial giants in transactional work and litigation. Last but not the least, about myself, my name is Renu. I'm the moderator for this session. I am a co founding partner at a boutique disputes firm called Olive Law, and we'll all be here today to discuss this very crucial topic. We're going to basically navigate around six subtopics, and I'll just mention it for the benefit of audience. I think we'll broadly cover first the contours of Section 34 in terms of whether the courts are overly interfering in awards today or not. Then we're going to touch upon modification of award. We're going to also talk about conditions of deposit, resisting enforcement of foreign awards, curative petitions, and in the end, we'll come to some best practices, international best practices. And all of this will be tied together in the context of finality of arbitration awards. So, really, what are we looking at? We're looking at that the parties do get an award, and is it really final? When you say final, do they get to enjoy the fruits of the award at an early stage, or do they really have to jump through several hoops before they can see any fruits of the decree at all? So I'll start with Akshay. I think Akshay, if we can broadly start with, what do you think, in terms of jurisprudence of Section 34, is it more or less stabilized today between different high courts of the country, also the Supreme Court, or do you think there is still scope today for different views coming from different high courts, different degrees of interference in awards coming from different high courts? Or is it more or less a balanced, consistent approach? So, your thoughts on that, please.
So, am I audible?
Yeah.
Yeah. So, I think that certainly from a jurisprudence perspective, in the last 12 years that I've been practicing, there is much more consistency, especially after the 2015 amendments. We have specific terms mentioned in our statutes. We know that any challenge is not a review on the merits of the dispute. Uh, and we have the benefit of more and more cases looking at what defines patent illegality, what defines public policy more than we did earlier. And we are all know the problem, which is that it is that arbitral awards should be, there should be a little bit of deference. There should be a pro enforcement strategy, there should be a pro enforcement bias always. All of that, I think, is filtering through, and there has been a lot of incremental change. But I feel that the tests are the same all over the world. I mean, we still use the New York Convention, but we mean different things. And the lack of consistency, if there is some, is because of change in judicial culture. There is no doubt that the commercial centers, the Delhi High Court, the Bombay High Court, the Madras High Court, where there's a lot of commercial litigation always happening, there is a large change. And on the same facts, you would hope for more consistency uh, across courts. But at the end of the day, there is always a tussle between doing complete justice in each matter uh, versus actually not interfering with an award. Obviously, the culture has to continue to evolve. I would say that my experiences in a few high courts were more positive, and I was surprised to see, because us sitting here in Delhi, we feel that those other high courts probably are not as commercial minded as ours, but it's not necessarily true. But no doubt, a lot of awards are domestic awards. District courts are looking at those domestic awards. In every other case, they're trying to do complete justice, and you're trying to teach them that, not teach them, teach is a very wrong word, but the policy that is trying to be filtered down is to not interfere. So it's really, really hard to uh, to convince judges or create that judicial culture that the award may be wrong. And in that particular case, if we were to interfere, there is no doubt that maybe somebody would get that the right party ultimately either gets the fruits of the award or gets or is able or is not suffering a award which is in the opinion of the judge wrong in law. The difference is that as a policy of not interfering, there is bound to be differences all over the country. I think if I look at it from the angle of jurisprudence, I think it's getting clearer and clearer. Every example of a case uh, every case that is being tested in courts gives us some more clarity. But that judicial discretion, changing the judicial culture to make it relatively more consistent, because the words patent illegality mean what they mean. We know that there should not be a plausible that that even if the interpretation is a plausible one, the award should not be set aside. But what is plausible, what is not plausible, is always a difficult decision to make, and it depend and there is still some inconsistency, I would say.
Ronak, any quick comments on that? I mean, what has your experience been, and what is, I mean, we all, I perhaps feel, share the same experiences, but any comment on where do you see, are the inconsistencies, or where do you see a more stabilizing, balancing factor in the way and manner in which the jurisprudence is evolving?
I think we'll come back to this a little bit later in the discussion, but I imagine that the courts are starting to come down pretty heavily on just process arguments, or picking up perhaps just substantive, more merit based arguments. Of course, the law is what it is, but we can get pretty creative about how we fit our arguments into the pigeonholes that Section 34 provides. I think we still struggle to, for example, patent illegality and public policy. These are always going to be those kind of the broader grounds of Section 34 that we can play around with a little bit. But having said that, I think at least when it comes to broadly process arguments, I think the courts are less interested now. I think the courts are also less interested in looking at very evidence heavy or merit based arguments. So I won't say it's a complete no. We figure it out, but I think it's starting to get a little bit harder.
Okay, thank you for that. Moving on to the next topic, and Hina, I mean, I'd like you to sort of talk about this. We speak about modification of award. So, the judgment came in Gayatri Balaswamy, and modification even prior to the judgment, in some parts was happening, particularly on interest. But this just kind of clarified principles to an extent that, okay, if you can severe, it doesn't impact the severed award, and if you can save it, that yes, you can go ahead with modification. But do you think this kind of makes it better or worse in terms of enforcement of the award? Because once you've got the award, then you've got a challenge, and now you're talking about modifying, so the modified piece, does it make it harder for the enforcement stage? Does it make it better for the enforcement stage? What is your thought on that?
Right. Thank you, Renu. So initially, I wanted to begin my conversation with what is finality. As Renu rightly said, that party should be able to enjoy the fruits of the arbitration process. So finality, if we put it very simply, is a resolution. It's a complete resolution of the disputes. So this the parties, what they seek is a resolution in the arbitration process, which culminates into an arbitral award, which, as the Arbitration Act says under Section 35, is final and binding. So the courts have initially, like before this modification trend started, the court had only two options: to set aside or to uphold it. However, then this limited power of modification have been exercised by the courts at district level, at high court level, and the Supreme Court level also. So this judgment of Gayatri Balaswamy, it has recognized that this is an inherent power the court always had, being a civil court. So this power to modify the award, and it doesn't mean to sit as an appellate court over the award. It only means that you tweak the award. Tweaking is the right word, because you don't change the or alter the character of the award, because that will amount to an appeal. So tweaking, I would say that tweaking is better than total waste of time, because if you set it aside completely, then you're just throwing away the entire arbitral process. So I must disclose that I was representing the petitioner in this matter, but my views are completely uninfluenced by that. So what I feel that the tweaking or the modification is in the interest of saving the arbitral process and by secutor the award, because if the court finds that there are things which can be fixed with the arbitral award, and the court doesn't need to go to that far end to set it aside, the court then fixes it, and then it will then the award will be final, being a decree of the court, and it can be executed under section 36. So I feel this is a step towards the finality of the award, because if we if like um, rather than living in this dichotomy, either to set aside or to uphold it, we should have like a small this leeway with the court, that if there's small errors, then the court can fix it, rather than if and also it will help in enforcement, because if there are computational errors, the enforcement court will be confused that, like, it's impossible to execute this award. What exactly is this award? So I think this is a right step towards the finality and the conclusion of the matter in arbitration.
Okay, okay. So, I mean, what you're saying is that it effectively steers the award more towards a finality, wherein you take away the pieces which make it susceptible or prone to, being set aside. So you just discard those pieces to the extent you can sever from the main award and move on and try and enforce the parts which are untainted. Okay, okay. Thank you for that. Next, we have a topic on the deposit conditions which courts inevitably impose on every challenge. And I think my question to Ronak on this, after I make one small comment, is this that I mean, we all see that, inevitably domestic awards are challenged under Section 34. And I mean, it is very rare that a large award, would face a situation where the court does not even issue a notice and you get a dismissal, without sort of at a pre-notice stage. So what we usually end up with is a situation where you have an award, you file a 34, and you say as the respondent that, fine, I mean, let them deposit the money, and then you withdraw that money, and as the award holder you believe that is some fruit of the decree that you might enjoy while the challenge is pending. So on this, what are your thoughts? And one thought that, if I may share before you share your thought, is that I believe that in this scenario, I don't think that the award holder actually ends up enjoying any fruit of the decree, because the bank guarantee that you extend, which is almost a mandatory condition today, takes you in a negative cash flow situation. For any bank guarantee to be extended, the banks insist on 100% cash margin, you take out the money, you service it with the bank guarantee, you give the bank 100% margin. So net you actually have to pay the bank charges, so you go cash negative. I'm not sure this is the practice which other jurisdictions follow, of insisting on a bank guarantee to withdraw the money. So what are your thoughts on that? Does this process really help anybody at all, or is it burdening the award holder even more?
So just to put it in some context, we've of course coming out of the era before the 2015 amendment, where we didn't have we used to deal with an automatic stay situation, and therefore it meant that award holders would reap the benefits of the award only much later, once the section 34 had been disposed of and you went through an execution process under section 36. So coming out of that, and with the it's a kind of legacy problems that brought, the 2015 amendment in that way was very pro enforcement and pro finality in that way as well, where it's saying, okay, there's no automatic stay. To the extent you do want to stay, you're going to have to comply with the same tests that, for example, for a monetary award you will have under order 41 of the CPC. Now, what that means is that the court now it's almost intended principally as a deterrent to firstly challenge or request a stay. But unless you have really good grounds and therefore you are willing to pay the award upfront and say, I have a really good case, it's not because I'm trying to avoid liability. I genuinely believe in the merits of my argument. And coming out of that context, you're then looking at, okay, where you're right, absolutely, that it's more routine in India, at least Part 1 awards, to be challenged under Section 34 and for the stay to be requested. It's almost just par for the course for us. You're absolutely right also that when it does put you in a negative cash flow situation as the award debtor, when you're going to supply a bank guarantee, it's as good as depositing the money in court. So those are intended to be the deterrents, I think, and therefore they have a place of their own. The question really, I think, is step 2 for me, which is, once supposing, and in terms of practice, what I have seen, and that was your first question to me, what I have seen is, of course, the courts insisting on a deposit, whether it's partial or it's entirely the entire sum of the award. That is something that I think varies court to court. Some courts, of course, also try to balance it out and say, okay, partial deposit, partial bank guarantee, such that at least the entire award is secure. I've seen also some courts get creative and say, okay, we'll go down the security path. We're going to ask for title deeds to be deposited of sufficient property that of sufficient value. So there are those things. I think those better address the concern you mentioned about the economic effect of paying through a bank guarantee or making a court deposit. So I think a deposit of title deeds does get you there, and that's a good argument where you have, let's say, an operating business that has cash flow issues. Those are arguments that are viable when you're trying to provide security and tell the court that this is, it's not my intention to avoid payment. I'm willing to supply security, but don't affect my business. So those are things that parties are able to persuade, and where it's appropriate, courts have issued those kind of orders. But I think what I also have really liked in how it's played out recently is the courts getting more and more kind of, there's almost an apathy towards the government requesting these stay orders. They're putting them at par with private parties, saying, that MMRDA case, I think, that everybody heard of. The Supreme Court went up to the Supreme Court, but then they had to eventually deposit 1,100 plus crores upfront for the stay on the award. So those, I think, are definitely very welcome changes from the pre-2015 era. And what I was mentioning about step 2, for me, I think where I think there is room for argument is as to what happens once you make the deposit in court. Are you then going to permit parties, for example, to withdraw the sum. If it's a guarantee, then of course neither the award holder benefits from a guarantee, nor does the award debtor benefit, because frankly it's just the bank, frankly, that's getting paid some commission on the guarantee, but nobody's receiving anything. It's just a formal security. So I think courts looking at the forms of security that can be provided, and who does it benefit. Of course it secures the award, that's value in itself, but who does it really benefit? Is it worth the cost? And can we do something by which, let's say, an award holder can actually withdraw a sum and not have to wait until the matter is disposed of? I think those are very good considerations that we as lawyers should explore a little bit more in a more nuanced way when we're arguing those applications.
That's interesting. So, in a way, we're looking at balancing the fact of securing the money plus letting the person who succeeded also enjoy without going through additional financial burden. Okay. Hina and Akshay, very quick comments on this if you'd like to make, please.
Yeah, so I agree absolutely. With businesses run on cash flow, they need money right now. We all face the struggles of our clients telling us that you won the award for us. How does it matter to us? My cash flow is still weak. But I think it makes a whole lot of a difference in because I've had cases where we got a deposit and cases where we didn't. Uh, unless you're litigating against the government, the value of being secured for the award is huge. The enforcement process is when there's no money available is a very difficult and long process. So net the change, even though it happened very early on in my career, that people started asking for deposits because I saw a couple of 34s where automatic stay was happening without deposits. It's a huge change because every time I tell a foreign client this is the timeline, and somebody asks me what about enforcement, that is when I start struggling with how many years. And this means that we are suffering the negative cash flow. We are not going to get the benefit of that, but that is the cost of doing business for the purpose of getting the award. So with all its problems, we should no two ways about it. It's really good that this at least this has happened. That's all.
Interesting. So from your perspective, it helps to have a security for a rainy day, for a judgment debtor who actually is going to just like squander
Correct.
out
And there are
his
many
money.
large business houses who could end up
Yes,
being that route, we
yes,
all know.
absolutely.
So that is huge value.
Absolutely, absolutely. Hina, any comments from you on that?
I think they both have covered well, but I just wanted to add one thing that it's a best practice to have because it's very difficult to locate the assets to recover your the amount, because if you keep on looking and the person never shows up in the enforcement proceeding, and like so many times we face this in court. Like I feel enforcement is more difficult than the entire arbitration process sometimes. So I think this is the best practice we should inculcate in our process.
Okay, thank you for that. Moving on, and Hina, this topic is for you and also Raunaq for you and for sorry, for Akshay and for Raunaq to also chime in. I think we can now talk about resisting enforcement of foreign awards, because when we talk about finality, I mean, we've talked about domestic awards, the 34, the ordeal that it does become for award holders in those scenarios. So, to that extent, do you think one could say or argue that finality may be a little less for a domestic award, but maybe a little more for a foreign award when it comes to enforcing it? What are your thoughts on that?
Yeah, I agree because it's the image also that we have to take care of as a like an enforcing state. If you see Section 48, it's a mirror image of Section 34, which lays down the grounds on which you can challenge the enforcement of the award. There is this concept of public policy, if you see, which is there in both 48 and 34. So if you see, like it started from this judgment of Renu Sagar, which has narrowed down the concept of public policy, but which subsequently led to some expansive views by saw pipes, and then ultimately this amendment has come where it like broadly defined the structure. And recently we have seen cases that where many judgments have interpreted it very restrictively, that public policy is only these and these grounds. In fact, in this judgment of Government of India versus Vedanta, Justice Indu Malhotra held that there should be great hesitation in refusing the enforcement of a foreign award unless it is affected by fraud, corruption, or undue means. So only these grounds, which shows that it has narrowed down, and we are pro enforcement, and we don't want our foreign awards to be stuck at the enforcement stage. So I think that is a step in the right direction. However, I think we need to adopt international public policy in our statute also and in the practice as well. So I think this is my suggestion.
So what you're suggesting is maybe have legislatively defined separate grounds for a domestic award, a pure domestic award, and then an international commercial arbitration, which results in a domestic award as well. And the third category, which we already have in 45-48, which is a foreign award. So is that what you're saying?
Right, and I want, like, what I suggest, that the standards should be at par the international level.
Okay. Okay. Akshay, any comments on that?
So I think the standard is at par with the international level. It because the word public policy means what it means. I think what legislative change may do, that public policy in the context of a foreign award only means this, or even otherwise, will do is start another process of slowly changing people's minds, because you can write what you want, but ultimately it's the interpretation of the award. One of the things I often struggle with is advising clients who are about to invest in India, wanting to know if there is a difference between, is there really a difference between 34 and 48? Because ultimately, because I am investing in India, ultimately I have to enforce it in India anyway. So really, can you tell me? And I can point to many examples. I mean, I've done a couple of them and gone well, but I can't say with any certainty necessarily that anywhere I enforce, it'll be better than a 48. I can rely on a few judgments, but I have to go where the assets are, and might as well take a seat somewhere else in India and ensure that, at least for the setting aside process, happens here rather than it being tested somewhere else, because that's where the assets are. So you make all these decisions. And again, when I compare, I don't think it's about right or wrong at all. I think there are different factors for why our large and vast country and the courts everywhere operate differently. But yeah, these are all things that are good. Like those are the judgments, and uh, that have far-reaching implications. I can use these few lines to give a client some more comfort that ultimately, when I enforce, it's not going to be as hard as the 34 process.
So, to sum up what you said, what you're saying is that, I mean, if you're eventually going to enforce in India, you might as well have your seat in India to be able to deal with your 34, and if it ends up being a domestic award, or to have a 48 if it's a foreign award. That's broadly what you're saying.
That's right, and I think what I'm saying is that I mean, that is why the standard needs to be absolutely different. The sad reality is we choose, the business wants certainty over justice. So when I mean, of course, after they lose, they want justice, but at least before, when they're finalizing their contract, they want certainty. So it's hard for me to say that uh, at this point that definitely it's going to be the grounds are so far apart in 34 and 48 that they will not change. There are now more and more and but frankly, as a matter of how the what the New York Convention says, public policy, if we statutorily define the meaning of public policy in foreign awards, why not for 34? Of course, if it's a policy, I mean, apart from patent illegality, there should be no difference. So if it's very hard to set aside, to refuse enforcement of a foreign award, then all those other grounds that are available in 34 for us should be equally hard, with a with the Indian government deciding that at least for domestic awards, we will continue to look at it from patent illegality. But public policy is used in 34 in the same way. So sorry, those were a few rambling thoughts, but I feel like uh, more change. I'm not super pro that we need to have one gradation for international commercial arbitrations, one gradation for patent illegality. Essentially, the way it's defined, it's the same for foreign awards and international commercial arbitrations. Maybe let it remain the same, and then I can say with and if it is going to be actually different, then I can say with confidence that you will that the grounds for refusing enforcement and the grounds for setting aside an award, at least for an international commercial arbitration, are the same, or are they different? Yeah.
I mean, that's interesting because I mean, like you said, if public policy is defined for 48, we can also look at doing that for 34. But if we really, if I was to make an Excel sheet and write down those 10 judgments, and then associates started right with bucketing, and these are the five heads. Now, if we follow that trend and go right up to Sangyong, you're able to literally bucket and say that okay, interpretation of contract you're not going to get through, reappreciation of evidence you're not going to get through, some evidence you're not going to get through. So I feel maybe there is no of course lawyers will continue to be inventive and will try and sort of come up with something every time the client wants to challenge an award, but by and large we've got the guardrails which say, okay, no, no, no to those 10 things. Your window really is just narrowing down for an intervention. Ronak, any thoughts from you on that?
Sure. So I have, just from my experience, so just to put in context what Akshay and Hina have said, the Supreme Court a few years ago did clarify that the standards for review and the manner in which they will interpret the same grounds. So Hina's right, actually, the grounds are largely the same. There is some difference as to patent illegality and a couple of words here and there that are different, but the Supreme Court's very clear that they are differential standards that apply. You will not review an award on public policy to the same degree that you would review a domestic award. So that standard, they are very clear. It's the wording may be similar or identical even, but the standard of review is very, very different. Now, that's also important given that we're really operating under a New York Convention framework. For part two, we're looking at enforcing awards that are from 170 plus countries that have signed up to the New York Convention, and there is meant to be a certain degree of not just certainty, but also uniformity in the way that those grounds under Section 48 are reviewed and implemented in each country. So because let's say, I have a London seated award and I've got to enforce them in 3 jurisdictions, I actually do need to take them to all 3 jurisdictions at the same time in order to be able to benefit from simultaneous execution. Now, when I do that, I can't really have the Indian court lagging on reviewing something because a public policy argument's been made because I'm dealing with an Indian party, let's say. And at the same time, I may be sitting in Mexico and I can be sitting in Paris doing an execution of that exact same award. But I've got assets there that I'm enforcing against. And then the argument in those courts inevitably is that the Indian court has concerns on this award. So you're just going to have to relax for a bit until they decide what they with this award. Now that's really a very untidy situation. So the intention actually under Section 48 and the standards of review under Section 48, keeping that to a higher standard than we do for Section 34 is therefore critical. From my perspective. And I think, broadly, I just wanted to tie up what everybody said so far in that way.
Thank you. Thank you for that. I think it ties up the foreign enforcement bit very neatly and makes it less untidy than what Ronak said, the situation is. Um, Moving on to curative petition. I think we all are aware of the decision in DMRC case, which was very unusual, which went to a stage of an award going to a single judge, I think, confirming the award, DB, correct me if I'm wrong, but single judge confirming the award, DB setting it aside, then coming to Supreme Court in first round, but the Supreme Court says no, the award is okay, going for a review, says no, it's okay, and then eventually a curative where the court says no, it's not okay. So where does finality, I mean, for a litigant, what do you tell your foreign clients now, that okay, where is the finality to an award, where the clients know that there is this new beast curative petition which is waiting in the docks, and every party today is going to try and the losing party will definitely try and take a shot at the curative, and not sort of leave it unused. So what are your thoughts on that, Hina, and then Akshay, your thoughts as well on that?
Right, Renu. So it's very unfortunate what happened in the DMRC judgment, because it's uh, like there are so many principles of minimum judicial interference. And like Akshay said in the beginning, there is this judicial culture that you have to inculcate in our system. So what I believe that curative power, which initially started with the judgment of Rupa Hura versus Ashok Hura, in order to prevent miscarriage of justice. So the term is very heavy and very this gray, miscarriage of justice, and usually historically it has been used to prevent violation of fundamental rights and in criminal matters. Though there is no bar in using it for the commercial cases, but what I feel is that what the court needs to see, there has to be a gravity for it to exercise its power of curator. Like, I want to draw a distinction between this curative exercise in the stamping matter versus the curative exercise in the DMRC matter. If you see the stamping matter, that issue that whether the arbitration agreement, which is not stamped, can be acted upon under Section 11 or by the arbitrator. So this was plaguing many arbitrations at that time. So it almost virtually the arbitration has come to a standstill. Uh, the court suo motu took this curative into account and separated it from the facts and just took the legal aspect of the stamping and decided the matter and set the law correctly. Was this what happened in Deva? See, it was fact specific. So there was actually this intermix of this patent illegality and miscarriage of justice. So the court, I feel it should have clarified what is miscarriage of justice and how is it applicable to this case, because what I feel that this because this judicial culture, I feel it's not the exercise of curative power; it is to exercise it at the right place. This is needed because this repeated and consistent exercise of curative power would actually be a grave danger to the finality of the award, because awards will never reach finality. So I feel I think it has to be a self-imposed restraints or the court can themselves put on themselves. So I think this curative part is the power is not wrong, but the exercise of it has to be uh, judicial mind has to be applied, I must say.
I think one comment I want to make is, of course, we all say that courts should be restrained in terms of not interfering too much, but perhaps it is also time for lawyers and clients to show some restraint and realize that at some point you have to give up and pay. So I think the concept of restraint must apply equally or unequally to lawyers and clients as well. Akshay and Raunaq, what are your comments on that?
Sorry, last, yeah. So I don't know. I mean, while we all want clients to behave reasonably and lawyers to behave reasonably as well, I think intervention has to come from the top. If we create incentives to stop doing it, such as very heavy costs like they do in various jurisdictions, it will stop. I don't think fundamentally Indian clients are different from foreign clients as long as you create the right incentives. But you're right. This is also a case of lawyer culture, creating not ethics, but at least in terms of what to pursue. Yeah. Going back to the curative petition, the judgment, I think the issue is, of course, maybe it was the right decision, maybe it was the wrong decision. It's simply the stage at which it was done that created a lot of that made people uncomfortable, especially foreign investors. It's not. I don't think, for instance, that uh, there are going to be 15 arbitral awards set aside in curative jurisdiction in the next 2 or 3 years. That's not what is going to happen. There may be one. I think maybe 10 years will go by and there'll be none. It's quite possible. It's just about the perception it creates. My context, when I set out an email setting out, yes, you can do 34, then 37, which I do on, I think, a monthly basis when I explain to a foreign client what they're going to deal with. And then I say SLP and review. I've just added one more line saying curative. But 5 stages, it just freaks them out. I don't think anything is going to factually change. Everybody will tire the curative, and my view is most of them will fail. Maybe all of them will fail, but it just creates a perception that ultimately, yeah, the award is absolutely not final, and that perception is everything when it comes to choosing. I mean, we haven't spoken at all about choosing India as a hub for neutral parties, whether in South Asia or anywhere, and we know things are so much better than they were. But this one thing, even though I don't think it'll change actual cases and how they're adjudicated, it's just a cut on the perception that we all are trying to create. And it's correct that arbitration is a process that works in India and helps businessmen to achieve their objectives properly as compared to other jurisdictions. But the effect of that one decision and the stage that it was made does create an impact, and we have to be conscious of it
I
and
think
deal with it.
in addition to, I mean, to just like put it in slightly different words, I mean, it's dented the image, right? And I would say that, I mean, you're right that we may not see courts doing this over and over again, but it does give a window to the parties to explore this. And for every party to explore this, which means that you're going to sort of slide in a curative, you're going to get it listed, you're going to, maybe luckily get, notice issued on that, and then that finality, is again questionable for the period that it's still hanging, at the last stage. Raunaq, your final comments on that?
So I'm gonna actually maybe pick up a little bit on what we discussed on Gayatri Balaswamy as well in this context. I want to actually I do a bit of BIT work as well, and I want to actually put this a little bit in perspective. I'm not the government's greatest advocate, but having said that, both Gayatri Balaswamy, where we're talking about 142, and curatives, which of course are an invention of the Supreme Court. Now, these are known risks as far as doing business in India is concerned, whether it's for a domestic party or a foreign party. These are known risks. The Supreme Court has those powers, the Supreme Court has those procedures. Now, the fact that, as Hina mentioned, the fact that they have invoked those powers and those procedures in the arbitration context most certainly is novel. It kind of shocks everybody a little bit and say, oh, my God, agreed fundamental rights, you can do this when you're dealing with, let's say, matters of national importance. But really, do you want to be doing this in the context of arbitral awards, especially when, we're walking the walk on being a global hub? So in that context, most certainly it does cause that shock value. Having said that, for me, I have never not advised a client that there are these rather unique facets of the Indian Supreme Court. It is a little bit unpredictable, and those, for me, those risks are have always been baked into the system. The fact that we are now seeing that play out is, and again, as Akshay said, it may not play out for a very long time further. but it was definitely for me a known risk. And to be very honest, I personally don't. Again, and not to comment on the merits of those disputes, Gayatri Balaswamy, I genuinely do think that it was quite a it was a very unique situation. They've invoked 142 powers. It's in the context of, a lady who's been dismissed following a sexual harassment complaint. We are pro welfare, pro worker. We are that jurisdiction. So for me, it's not. And I agree. It's good. It's better. It would be horrible for any client, including in that case, to have to go back to an arbitration if they were just going to, as Hina put it, tweak. But even if you were to make changes, I feel Gayatri Balaswamy is pro user in that way. It may or may not be pro arbitration, but it is most certainly, I think, and specifically in that case, pro user. And it comes back to the point of finality. That for finality, and I just want to put finality also in context. Finality, drawing on the New York Convention, what they meant when they said, that an award is to be binding, has actually different jurisdictions have picked it up differently. There are some who will say an award is final and binding when it's delivered to the parties, and that's that. Our law is not so different, but it's worded differently to say, subject to provisions of Part 1, an award will be final. Now, subject to provisions of Part 1, at least in the post 2015 era, we're actually looking at it, it doesn't automatically make it subject to it, or not final simply because the Section 34 has been admitted. So those are, I think, eventually the moment you have the award, you can take it to any jurisdiction, anywhere in the New York Convention framework, and have it enforced. And that's really what finality means. And unless there's a stay under Section 36, your award is final. So for me, the fact that we have to litigate as to the challenge, that for me doesn't, it most certainly is an unpleasant outcome for a client. But having said that, it for me doesn't necessarily dent the finality.
I tend to agree with you, Ronak, because I agree that the finality is not so connected to the challenge as to the enforcement, because otherwise the situation would be the same as a decree in a court, right? I mean, you get a decree, you've got a first appeal, you've got a second appeal, and at the same time, I mean, you do have the reciprocating countries convention where you can, seek enforcement of that decree. So I do agree with that view. I think we are running short of time because I want to keep 5 to 7 minutes for questions from the audience. Last question, and Ronak, only to you to save time. Maybe if you could talk to us about some international best practices, which you've seen in other jurisdictions, which aid in finality. And finality here, I mean, both in enforcement and also what we discussed in challenge, even though you do not agree that the finality is towards the challenge, but yeah.
So I think, towards from a finality perspective, of course, again, as I said, there are better worded provisions in Singapore, let's say, where they say once the award is made, signed, and delivered, it's final. Now, that's a far more objective test, where you say, okay, have I received a signed award, and is it the correct arbitrators, and off you go. But when you're talking about, as I mentioned earlier, and I won't repeat myself, but our provision is worded differently, and there is scope for argument there as to when it is final, what happens if a 34 is pending, what happens if a 34 is pending, but the stay has been granted, what happens when stay has not been granted. These are all available arguments, and I don't think the law is that clear on them yet. So I think from a finality perspective, that is most certainly, one thing that other jurisdictions do clarify a little bit better. Institutional rules have started to clarify this, by the way. So a lot of institutions will make that statement within the rules that the moment XYZ formalities are complete, the award is final. So even where the legislation is not clear, then if you are in an institutional framework, that clarity does come in. So those for me are the principal points. Having said that, even for example, the recent amendments in the UK where they've amended their act to bring in the summary disposal process and said that where essentially you have a case that does not have a real prospect of success, that you can bring in a summary disposal application. And then, of course, it almost helps bifurcate. Now, traditionally in arbitrations, we do tend to bifurcate at least liability and quantum. But what this does is it allows you to even bifurcate issues and say, we're going to pick up a few of the issues to streamline those that actually go to trial. And that way, you've got a few issues out of the bucket, and then you take that. If to the extent anybody is aggrieved by the dismissal of certain claims, then that can go through a parallel process, while your trial is limited to only those that are truly found meritorious by the tribunal, at least at the first instance. So I think all of these help us. One is to directly answer your question was the first part, but I think it is even helps us streamline the timelines that are involved in bringing finality. We don't really need an arbitration or an award to become final right at the end of the arbitration on all issues. There's absolutely no harm in picking up those issues in a staggered way, dealing with them through staggered awards, and having that through reciprocally staggered court proceedings to the extent required. I think it just makes things efficient.
Thank you. Thank you so much, everyone. And we have some time for questions from the audience. I'm not sure if there's somebody there to sort of.
Help us. I see someone's raised their hand on the list of attendees, but I don't know.
Oh,
So
there
you
is
can type your question.
Q&A. Yeah, I think.
Oh, there is a Q&A box.
So there is Muskan from Bhopal. Muskan, would you like to ask your question?
It's
Oh.
She's not able to unmute herself.
Oh. I'm not sure.
Should we drop it in the chat box, perhaps, Muskan?
Yeah, maybe you can type it, Muskan, if you're not able to unmute yourself.
It's fine.
In the meantime, should we check if there are any others?
Yeah, I'm not sure actually how to figure it out because, yeah, I mean, is there anybody in the audience who'd like to ask any questions to the panel? I think they're all very clear with the topic and nobody has any questions, which is a great success parameter for us. But thank you to my co-panelists, Akshay, Raunaq, Hina. This session has been hosted by NPAC, and I'd like to briefly introduce and talk about NPAC as well. NPAC is the Nani Palkhivala Arbitration Center. It was founded in 2005 in the memory of preeminent jurist Nana Bhoy Nani Ardeshe Palkhivala. It was established by the Palkhivala Foundation to carry forward the values he cherished, which is clarity of thought, fairness in practice, integrity in public life. What sets NPAC apart is not only its outstanding panel of arbitrators, which includes judges, senior lawyers, chartered accountants, civil servants, engineers, and technical experts, but also its commitment to best practices in line with leading international centers. Today, it has a presence both in Chennai and New Delhi, and NPAC continues to serve as a bridge between tradition and innovation, between India and the world, committed to building arbitration that is efficient, credible, and accessible. We do have a question from the audience now. Yeah. Hina, do you want to take that? This is on modification. So I'll read the question for the audience. as the recent judgment highlighted modification of award, but the extent of modification is not defined. And how can we differentiate judicial activism and overreach in the same case?
Well, it's a good question because the judgment is not clearly defining the contours of the power of modification. However, it says that it's a limited power. It's not a very extensive power. It is limited only to cure the procedural defects, if there are any, or to also fix the interest rate. So if they can reduce or increase the interest rate, but nothing else. It also respected the principle that that it will not lead to review on the merits of the award. So in a way, it is it we since the court says it's part of the inherent powers of the court. So it's not a judicial overreach per se. It is something which is inherent in the powers of a civil court. And the other thing that it will, I wouldn't say judicial activism, but yeah, to some extent, to save the arbitral award, the courts have come up with this limited power of modification. I hope that answers your question.
I just want to make a comment here, which is maybe in 10 years, or maybe sooner, we might see a situation where, there is a zero award and the party which loses, goes to the court and says that, if you set aside this award, which is a zero award, the reverse of that is that, the award is one. And I think this argument was made in some Delhi High Court reported decision. I do not recall the name. So perhaps on a contour of modification of award, today what it helps us achieve is that if you have an award where you've got some tainted portions and some untainted portions, and you can sever and separate, take home the good parts, leave the bad parts aside. But in a scenario where the entire award or the tribunal says that look, you've got no case and we are rejecting your claims on merits. Now if that award is set aside, would courts go to a stage, or the legislature go to a point that they will say that okay, now let us invent a system where setting aside of an award which says that your claims are dismissed will mean that your claims are allowed. So yeah, that's
So on
what.
that issue, I wanted to tell you something. In fact, there is one case I am doing. It's a nil award. So the arbitrator has rejected both sides' claims, claim and counterclaim. And the other side, the counterclaimant has approached the court to challenge the arbitral award, saying that it should be set aside only to the extent of counterclaim. Obviously, they didn't want to revive a claim also. So the question, what we are opposing is that it is inseparable and it is something interlinked. We can't set aside only a portion if it's not severable. So I think that
Yeah,
may
yeah, interesting.
yeah.
Any parting thoughts from all of you? Maybe 20 seconds each. I think we've run out of time. So parting thoughts, Akshay, Raunaq, Hina.
Oh, yeah. No, we quite enjoyed the discussion. I mean, I felt that we went into the same things we discuss about finality of arbitral awards in India, but I enjoyed all of your insights in things that I thought were pretty clear in my mind. So I enjoyed the session.
Raunaq.
I only wanted to thank you, Renu, for doing a fabulous job with this panel, and to my co-panelists, and to NPAC for having us.
Thank you. Hina.
Yes, I would like to thank you, Renu, and all my co-panelists, and it was an enriching experience for me as well.
Thank you. Thank you, everyone. That brings us to a close to this session. We hope you enjoyed the session. Thank you.